Good morning, everyone, and welcome to the first panel for the day. My name is Raul Pangalangan. I'm a judge at the International Criminal Court. I am on leave from the law faculty at the University of the Philippines. I have on the panel today three of our colleagues who will address the focus on crimes specifically addressed within the Tokyo judgment. They will explore the following themes. What crimes were adjudicated, and I will shift to some jargon here that will be the material jurisdiction of the court. Along those lines as well, the nexus between war and peace. We will also deal with the matter of personal responsibility, who were charged at Tokyo, who were found guilty. We will also address the question of direct individual responsibility during and how it was handled at the trial. And of course, in the end, look at the lessons that we learn from this episode. I will do a quick run of a brief introduction of the speakers, and after having conferred with the speakers yesterday, we will skip the usual part that was done yesterday, which is the exchange of questions and answers among the speakers, and jump directly to questions from the audience. So please be prepared with your questions for the speakers. The first is Professor Marina Aksenova, who teaches comparative and international criminal law in Madrid. And Marina wrote her thesis on complicity in international criminal law. And as a judge at the ICC, what I found most interesting in Marina's CV is that she worked for the defense teams at the International Criminal Tribunal for the former Yugoslavia, and also for the trial chamber at the ECCC, the Khmer Rouge tribunal in Cambodia. The second speaker is Professor Robert Cribb, Professor of Asian History at the Australian National University. Robert is the co-author of the book Japanese War Criminals: The Politics of Justice After the Second World War. This came out in 2017. And he's currently working on a history of Japanese wartime atrocities. And the third speaker is Professor Matthias Zachman, Professor of Modern Japanese History and Culture at the Free University, Berlin. Matthias, before that, was Professor of Japanese-Chinese Relations at Edinburgh in Scotland. He is a member of the German Bar, and he teaches on the development of international legal thought in Japan for the period 1919 to 1960, among other interests. So, ladies and gentlemen, I present to you the first speaker, Marina.
Thank you very much for this generous introduction. Thank you so much for being here this morning. And of course, I extend my thanks to Nuremberg Academy for having me here in this historical building 70 years after the Tokyo judgment. So my topic today is crimes specifically adjudicated in the Tokyo judgment. And the lens that I will adopt in my discussion is that of temporality. That was the theme that was recurring in the first and the second days of the conference. And by that I mean the fact that we don't look at the judgment with the eyes of 1948, we look at the judgment with the eyes that we have now, and the judgment and the materials of the Tokyo trial are still subject for further reassessment and re-evaluation. And in this regard, I wanted to make three observations on the judgment in general, and then I will discuss three specific groups of crimes that were adjudicated in Tokyo. So three main features of the judgment are, of course, its fact-based approach that was already mentioned before. This is something very different from the way we see the judgment nowadays. However, I do not fully agree with a statement of Professor Cohen from yesterday that there is very little law in the Tokyo judgment. I would say that there is law disguised as facts. in the Tokyo judgment. And we may still refer to the Tokyo judgment in the future in discussing some of the legal aspects, for example, at the ICC, and I will explain what I mean by that later. The second feature is its extraordinary length compared to the Nuremberg judgment. The Tokyo judgment is more than 1,000 pages long, and the Nuremberg judgment was 200 pages long, so this is a big difference in length. Of course, this is not extraordinary given the modern ICL judgments that we have at the ICC, for example. And the third important feature of the Tokyo judgment is its lack of focus on individual criminal responsibility. And the judgment is explaining in quite some length the circumstances of the Japanese aggression, but spends only a few pages on individual responsibility of the accused. So this is, of course, strikes as something very different from modern international criminal law. So now we'll move on to three groups of crimes that were adjudicated in Tokyo and their relevance to our today's situation. So, as was mentioned yesterday, there were 55 counts in the indictment. Only 10 of them were upheld by the court. The first count is grand conspiracy count. And this is where Nuremberg and Tokyo judgment differ, because both Nuremberg prosecution team and Tokyo prosecution team advanced grand conspiracy charge. This was done to attach responsibility to individuals. So this was an instrument to attach responsibility. However, at Nuremberg, the grand conspiracy charge did not succeed. It was even broader in scope. It started in 1990 and ended in 1945, but the Nuremberg Tribunal rejected the grand conspiracy charge. The Tokyo Tribunal accepted the grand conspiracy argument of the prosecution and defined this grand conspiracy as, in factual terms, as the military, naval, political, and economic domination of Far East. Most of the accused, actually all of the accused but two, were found responsible under count 1 of the indictment for participating in the grand conspiracy as leaders, organizers, people who planned these crimes. What is interesting is that both conspiracy planning and preparation were treated as substantive crimes, not as modes of liability. And here is the first lesson for today. This is the constant tension of international criminal law to attach individual responsibility for collective offending. This started at Nuremberg and Tokyo, and I would say arguably we're still facing the same problem with attaching responsibility, individual responsibility for collective wrongs nowadays. What is different nowadays is that we have a very well-developed case law from the ICTY and ICC, which provides for molds for liability, which provides the formulaic language which was missing in the Tokyo judgment. So Tokyo judgment, it has law, but it's not formulated in a way that we're used to now. So, of course, the charge of conspiracy attracted some criticism by the contemporaries. Judge Bernard from France insisted on the use of complicity, and he also insisted on the fact that the emperor was the primary perpetrator and others were accomplices. Judge Paul also criticized it, and Gordon Ireland in 1950 also criticized the use of conspiracy, because he said that in domestic law it allows for the possibility of withdrawal of participants from the conspiracy, whereas at an international level such possibility was not given. I move on to the second group of crimes upheld by the Tokyo judgment. These are individual instances of aggression. So here the important lessons were several. Firstly, the Tokyo judgment did not define aggression. The prosecution built its case again around facts, and the Tokyo judgment just said aggression means domination and we don't need to go in technicalities. The Tokyo judgment also referred to its predecessor, the Nuremberg judgment, so in that sense it was legally better supported. And the other important element, of course, is the Kellogg-Briand Pact, which was supported to talk about the prohibition of the illegal use of force. Interestingly, the Kellogg-Briand Pact is celebrating its 19th anniversary this year, so it's an interesting parallel The defense, of course, raised objections. One was ex post facto challenge that was discussed yesterday, and the Tokyo Tribunal referred to Nuremberg Tribunal jurisprudence and to Kellogg-Briand Pact to counter that challenge. The other one, which I wanted to mention, is self-defense challenge. So the defense argued that it was possible under the terms of the Kellogg-Briand Act for Japan to unilaterally invoke self-defense. And the tribunal, in its quite modern interpretation of the limited scope of the right to self-defense, said no, the right to self-defense cannot be unilaterally claimed. And this is actually resonating very much with the discussions we have nowadays as to the exceptions to the prohibition of the use of force. Just 2 days ago, Brazil filed its observations to the UN Security Council, referring to the Kellogg-Briand Pact and saying that we need to be very careful in the way we use self-defense as an exception to the prohibition of the use of force. And Brazil was saying, let's be very, very strict. Let's not unilaterally invoke the right to self-defense to fight terrorism. The same kind of, or similar kind of arguments as to the exception to the use of force were invoked recently in the bombardment of Syria. So again, we do have the definition of the crime of aggression nowadays at the level of international criminal law, but I would say we don't have a full agreement as to the international law dimension of the use of force. So the third group of crimes adjudicated in Tokyo were war crimes, and we started the discussion yesterday. I would make two observations with regards to war crimes. Number one, they were discussed in substantive terms, in very, very factual and substantive terms. We talked about rape yesterday. I wanted to provide a short citation on torture today. So I'm citing here, torture. The so-called water treatment was commonly applied. The victim was bound or otherwise secured in a prone position, and water was forced through his mouth and nostrils into his lungs and stomach until he lost consciousness. Pressure was then applied, sometimes by jumping upon his abdomen to force the water out. The usual practice was to retrieve the victim and successively repeat the process. So I see some irony in the fact that this kind of torture was discussed in the Tokyo judgment, and the Japanese were found responsible for this kind of crime. And we are now, these days, also discuss the same kind of crime when we talk about the confirmation of the head of the CIA. So the definition of torture is again evolving. It's again resonating with today's events. This is why I think the Tokyo judgment can be assessed and reassessed in the future. So the second observation with regards to war crimes, and I will be finishing soon, are modes of participation. So there were two counts that were upheld in the Tokyo judgment with respect to war crimes. One was ordering, authorizing, and permitting violations of the laws of war, and the second count was recklessly disregarding the legal duty to secure the observance of the laws of war. So what was interesting about these formulations was the fact that there was lack of evidence connecting individual defendants to the factual situation on the ground. A lot of evidence, as we heard yesterday and the day before yesterday, was destroyed. So the Tokyo judgment uses, by large extent, inferential analysis. So building its case from bottom to up to the individual defendants. It is not alien to modern international criminal law when establishing mens rea to use inferential analysis. So it's not something uncommon. The standard of recklessly disregarding the duty to secure the observance of the laws of war is quite a low mens rea standard. However, this standard is replicated in the Rome Statute with regards to the civilians. The Rome Statute talks about responsibility of superiors who either knew or consciously disregarded the crimes. So recklessly disregarded versus consciously disregarded. So I expect if the ICC would rule on the responsibility of civilians in the future, command responsibility of civilians, perhaps the Tokyo judgment would be described and discussed. So I would like to conclude with a sentencing consideration of the Tokyo Tribunal. As I mentioned, the discussion of individual responsibility of the accused is quite limited. The responsibilities the sentences were quite uniform compared to the Nuremberg judgment. 7 people were sentenced to death, 16 to life imprisonment, 2 were sentenced to terms of imprisonment of 7 and 20 years. Responsibility was attached mostly based on the position of the accused in the hierarchy, in the Japanese hierarchy. For instance, the IMTFE convicted and sentenced to life Sadao Araki, Japan's Minister of War between 1931 and 1934, for his role as quote-unquote prominent leader of conspiracy to wage aggressive war and quote-unquote an energetic proponent of the army policy of political domination at home. So that was the discussion and description of his individual involvement. In contrast, the Minister of Foreign Affairs, Shigemitsu, was sentenced to only 7 years of imprisonment for his role and responsibility for the welfare of prisoners. Supposedly the link between his position and the welfare of prisoners was more tenuous, and supposedly the tribunal took it into account when assessing his culpability for sentencing purposes. And I would like to conclude with this observation. Thank you so much.
Thank you so much, Marina. We will now ask Professor Robert Cribb to address the topic, Treatment of Prisoners of War and Civilian Internees in the Tokyo Trial.
So good morning, ladies and gentlemen. Thank you very much for coming, and thank you very much to the International Nuremberg Principles Academy for organising such a great conference, and especially for the wonderful conference dinner last night. It was unusually good. One of the things we've learnt in the course of this conference is that we get one set of insights by looking at the trial in general and making general comparisons with Nuremberg. We get other insights by looking at specific aspects of the trial, by looking at the role of individual prosecutors, the roles of individual judges, the role of women, by looking at specific aspects such as Webb's judgment. Now, what I want to do today is to look at the way in which the Tokyo Tribunal handled the question of conventional war crimes against prisoners of war and civilian internees. There are about 300,000 of these who were in Japanese hands during the Second World War. That's a relatively small proportion of the total number of victims of the war, but nonetheless, they were a significant focus within the trial, and their experiences are also relatively well documented. So we know a great deal more about the experience of prisoners of war and civilian internees than we do about many of the events during the Second World War in the Asia-Pacific region. It's also the case, as we know, that some of the harshest sentences that were brought down in the Tokyo Tribunal were against those who were apparently found guilty of these charges, rather than the charge of crime of waging aggressive war. Now, the large number of prisoners of war and internees who were in the hands of Japanese forces during the war was a consequence of military and historical geography. It was a consequence of the fact that Allied forces in Southeast Asia were trapped on islands and peninsulas. They couldn't escape from the Philippines, from Singapore, from Java, and so they were captured in rather large numbers. In the end, around 160,000 Western Allied soldiers were captured. By contrast, in Burma and in China, there were very much smaller numbers of prisoners of war because defeated soldiers retreated ahead of the advancing Japanese forces. There were a large number of civilian internees in Japanese hands because Java in particular was to some extent a colony of white settlement, of European settlement. and those European settlers in Java decided not to evacuate as war loomed. So they too fell into the hands of Japanese authorities, who were largely unprepared to deal with such a large number of prisoners and internees. Now, the experience of most women and children during the war, and of some men, was of tedious detention in internment camps, where conditions gradually declined over the course of the war, very much in parallel with the deterioration in conditions outside the camps experienced by people who weren't interned. The experience for the majority of men was that sooner or later they were sent to labour camps, where conditions varied from harsh to appalling. The best known is the conditions on the Thailand-Burma Railway, where the prisoners of war and internees were put to work constructing a strategic railway between Thailand and Burma. They faced critical shortages of food, of medicine, of clothing. They faced brutal treatment by guards. They were, in many cases, forced to work long hours, even though they were sick, and as a result, there was a very high death rate. There were also cases of massacre of prisoners of war. There were also cases of death marches, where prisoners were marched from one place to another, and many died en route. Now, the Japanese and Korean and Taiwanese men who carried out these atrocities were, to a significant extent, brought to trial in those national level trials, sometimes called BC, but there were no C trials, so there were national level trials conducted by 7 Allied powers. Of the 5,700 defendants, roughly half were charged with crimes against civilians and prisoners of war, Western civilians and prisoners of war. The other half tried for crimes against Asian victims. And as we know, those trials lasted for about 5 years, produced 4,600 guilty verdicts, and somewhere between 600 and 800 executions, death penalties that were actually carried out. But the Japanese leaders in Tokyo were also tried for these crimes. That trial, or that aspect of the Tokyo trial, was problematic, as we've heard, because the paper trail linking Japanese leaders in Tokyo to the atrocities on the ground in China and in Southeast Asia was very thin. It was actually non-existent. And it was non-existent not just because of the destruction of documents. We know a great many documents were destroyed, but actually quite a lot of documents also survived. The paper trail doesn't exist because it never existed. And that is because there was a profound difference between Japanese imperialism and Nazi imperialism. Nazi imperialism had a program of extermination, a program of genocide, a program of eliminating ethnic groups, which was completely absent in the Japanese imperial program. What happened in the Japanese Empire was that the very large number of atrocities in China and in Southeast Asia and out in the Pacific were a consequence of local tactical decisions by individual soldiers, by groups of soldiers, by local officers who were, in effect, out of their depth. They were unprepared, they had no idea of how to handle the difficult situations that they found themselves in. They responded sometimes callously, sometimes brutally, sometimes they didn't know, they couldn't think of anything to do except to respond violently to local challenges. But there was no central coordinated plan of extermination, no central coordinated plan of persecution. It was all local tactical responses. In the absence of both a paper trail and a convincing policy framework which had led to atrocities, the prosecutors at the Tokyo trial resorted to two formulations. One was the command responsibility argument that had been developed in the trial of General Yamashita Tomoyuki in Manila in 1945, under which a commander could be held responsible for the behaviour of troops under his command, regardless of whether he had actually been firmly in control of those troops, but by virtue of the fact that the crimes were so extensive, the atrocities were so extensive, that he should have done more than he did to halt them, or to halt the atrocities, or to punish the perpetrators. The second formulation was a kind of inductive or inferential reasoning, which argued that the atrocities had been so widespread and so similar in their form that they must have resulted from policy for which no documents, no written records had survived. Now, in order to pursue these two formulations, the strategy of the prosecution was to flood the court with evidence. Hundreds of affidavits were tabled, sometimes a dozen, 24 every day. Very little time was given to examine those materials. They were not subject to close scrutiny. There was no time to allow them as close scrutiny by the defence, or indeed challenge by the defence. The intention was to produce an impression of massive scale and of overall pattern in the atrocities. The defence, it's important to note, was not allowed to respond to this flood of evidence by bringing forward cases of good treatment of prisoners and internees. The bench ruled that the defence had to answer the charges that were brought against them, which of course is standard practice. But the purpose of the flooding strategy of the prosecution was to create an impression, or create an argument for overall Japanese brutality. The defence was not allowed to bring forward evidence that would contradict that overall impression. The result was a number of convictions, and indeed most of the harshest convictions, most of the death penalties, were fairly clearly related to conventional war crimes against prisoners of war and internees. So the military men, Tojo, Kimura, Itagaki, Muta, Matsui and Doihara, were sentenced to death. One of the civilian defendants, Hirota Koki, was also sentenced to death. On the other hand, the lightest of the sentences, the 7 years for Shigemitsu, was also on the basis of crimes, of his knowledge of the crimes against the prisoners of war and internees. So the pattern of harshness for this set of charges is not entirely consistent. Now, it seems to me that three broad problems have arisen from the way in which these charges were dealt with in Tokyo. One is that the flooding strategy and the prevention of, or the prohibition on the tabling of contradictory evidence by the defence has led to an inaccurate picture of the comprehensive nature of Japanese brutality. So, amongst the evidence that was presented, there is very little that we would want to challenge in terms of factuality. But what was not presented was the evidence of camps where conditions were good, the evidence of good behaviour by Japanese troops, which would have challenged that claim of comprehensive violence, comprehensive and policy-based violence by the Japanese authority. And that picture created an image of collective Japanese responsibility for violence, which it seems to me was seriously at odds with the aim of the tribunal to establish individual criminal responsibility. A second major problem was that the abundance of evidence and the fact that it was mostly simply tabled and never thereafter discussed meant that there was serious ambiguity about what had actually been considered by the court. So we heard yesterday from Professor Orentlicher that there has been uncertainty over whether crimes of sexual violence were treated in the Tokyo Tribunal. This applies much more broadly. It's very hard to put a finger on any of those atrocities and say, yes, that was adequately dealt with in the tribunal. And that failure to deal comprehensively with individual atrocities has contributed to the feeling that the tribunal was inadequate. Third major problem, it seems to me, was that because conventional war crimes were brought up were adjudicated in the Tokyo Tribunal, but led only to a handful of convictions, a handful of death penalties, it has been very easy to overlook the national level trials, which actually prosecuted the perpetrators, the people who had carried out the vast majority of the atrocities. Perhaps if the war crimes had not been considered at Tokyo, it would have been impossible to ignore the vast scale of the national level trials. But because they were present in Tokyo, the scale of reckoning with Japanese perpetrators after the Second World War has largely been forgotten. Thank you.
Thank you. Thank you so much, Robert. Marina told us that the heaviest charge was grand conspiracy, not as a mode of liability, but as a crime in itself. And Robert now tells, sorry about that. Robert now tells us that the crimes, many of the crimes were actually localized in character, and that there were evidentiary issues along the way, precisely because of the nature of the way these crimes were committed at ground level. But I'm so glad, Robert, that you closed with a note about the national level prosecutions, because then that is at that level where they will look at what we'll now call crimes against humanity.
There was almost no discussion of crimes against humanity at the local level. They were defined as war crimes, and many of them used the formulation of the UNWCC, which included crimes against civilians in occupied territories,
yes. As in Yamashita.
As in Yamashita.
Yes. Thank you so much, Robert. And I now ask Professor Matthias Zachman to address the topic, Japanese responses to the concept of individual criminal responsibility in the IMTFE.
Thank you very much. And also many thanks to the Academy for inviting me, and congratulations for organizing such a successful conference. I have to confess that I prepared a manuscript of 20 minutes in my blissful ignorance or foolishness, and I will summarize it as much as I can. I was given the assignment to talk about individual criminal responsibility, but I beg leave that I will talk about this from my perspective as a historian of Japan and of the law. So what strikes me most about discussions and representations of the Tokyo IMT is that we often talk a lot about the IMT, but not so much about Tokyo, that is about Japan, meaning that many discussions are about the views of the judges or of the prosecution or of the politicians behind, the politics behind these two groups. But little do we talk and know about the Japanese, not just the defendants, but the defendants' councils or the ministries behind the councils, the study groups who work for these councils, the intellectuals and the diplomats and so on and so forth, who are all involved in this. And this creates the somewhat eerie impression that although Japan should be at the center, or is at the center of the Tokyo trial, after all, it is a trial about Japanese foreign policy and military policy and its crimes, that we do not so much look at their side. And this leaves the somewhat eerie impression that at the center of the storm, of all this forensic commotion, there's utter stillness, as it were, where nothing moves. So from a cultural history perspective, this is the perfect Orientalist paradigm. Now, there is, it has already been mentioned, this NHK miniseries on the Tokyo trial and the bench. It's the discussion of the bench, same perspective. And what I really want is an NHK series about the other side, about the Japanese councils and the diplomats and intellectuals and so on and so forth who were involved, and their tribulations and their discussions. That would be also fantastic. But unfortunately, we have research which has already made inroads into the Japanese perspective. So the fantastic studies by Yuma Totani, or Philip Austin, or Futamura, and of course also Higurashi in Japanese. But this is just the tip of the iceberg, as we have heard. And my little contribution is to look at the antecedent, or the prior history of all, because what also somewhat puzzles me is that the Tokyo trial is often treated as the ground zero of international criminal law, or of international law in Japan for that, which is of course patently wrong, because international criminal law has been discussed in Japan before, and international law also has a history. And there is a certain kind of path dependence from the Japanese side of how people were thinking about international criminal law and about international law, which very much shapes the Japanese responses to the Tokyo trial, and especially also to individual criminal responsibility. And I just want to quickly mention those factors which shaped path dependence, or which shaped the Japanese response. Now, just to deflate a little bit the lawyer's ego, the Western lawyer's ego, international law has a shallow history, as we know, and Japan actually very much in synchronicity with latecomer nations such as Germany, Italy, or the US has professionalized its international law as a discipline in the 19th century. Just to give you one example, the Professional Society of Japanese International Lawyers was founded in 1898, which is 10 years earlier than the American Society and much earlier than the German Society. That is because international law was preeminently important for Japan in its dealings with Western powers, and also in its dealings with China and Korea. But there was a certain wariness of natural law. Now, some of you have read Judith Shklar's Legalism, which is again patently wrong about Japan. Of course, natural law was known in Japan from the very beginning of international law reception, but it's just the fact that it was disadvantageous for Japan to use or to face natural law doctrine. It used it itself as a weapon, as an argumentative weapon against China and Korea, but being used by the Western powers against Japan was disadvantageous. So there was a certain kind of wariness. So the paradigm of the day was positivism, and that was what Japan used. There's also traditional opposition against international adjudication and arbitration, and also against multilateralism in Japan. Just because it is above nations, that is an infringement. Japan, which wanted to protect its sovereignty, early nationalism, and so forth, it was again worry against this kind of intervention. So there is also, therefore, there's an early thought in international relations that these treaties and conventions do not apply to Asia. This so-called Asia-Monroe Doctrine, which since 1898, since the American Hispanic War in Japan, and this is applied to successive treaties or institutions like the League of Nations or the Washington Treaties or the Kellogg-Briand Pact as a matter, which was Japan actively participated in it, but in internal discussions, it was very cynical about it, very derogatory, called it a bad law, which was legally void. Also, we have to consider that war criminals, there were war criminals, there was a discussion about war crimes and war criminals in Japan already during the wartime, but these were enemy soldiers who were captured and tried, mostly for aerial bombing, the Doolittle raid. So Sempan, war criminal trials were already active in Japan. And then, which is not well known, is the fact that there was also already a discussion about a war crimes tribunal or trial in Japan during the wartime, but with tables turned for when Japan had won the war. I have called it the IMT for the United Nations. That's my coinage. And I just recently found a Gijiroku, as they say, minutes of a committee which discussed post-war order of East Asia and the world when Japan had won. And because it's so interesting, this is part of this of the minutes of the committee discussion where they talk about the IMT-UN. And so one member starts. This is a longer discussion, but then it comes to the question of, are we going to do a tribunal? And they say, when it comes to peace talks for this war, I don't think that we should press the question of war guilt, senso sekinin. Our country should act according to the spirit of the 8 corners under one roof, that is, the spirit of the imperial way. The cruel punishment in the Treaty of Versailles quite pointlessly left the German people with a grudge for future generations, upon which Matsushita answers, I completely agree with Mr. Nagaoka's view. I think punishment is more a thing in Anglo-American thought. And then Amo Eiji says, I think public opinion is a serious problem when it comes to pursuing the question of war guilt. I wonder whether the Japanese people will be content not pursuing war guilt. Upon which Nagaoka answers, victorious countries often tend to incite the furious minds of the people even further. But the Japanese government must not adopt such a policy. The Japanese people must attend to this matter with the so-called spirit of the imperial way. And then Matsushita, the Japanese are a people who easily cool down. They don't hold a deep grudge and think of revenge like Western people do. And then Nakagawa, who leads the committee, concludes the discussion, all right, with the decision that we have no objection in seeking reparations, but that we do not seek, from the US mostly, but that we do not seek them on the basis of war responsibility, let us move on to the next item. Now, you could brush this away as the usual nuts talking about utopian dreams, but these were actually important people. Amo Eiji was vice foreign minister at the time, later a Sugamo prisoner. Now, Nagaoka Harukazu was judge at the Permanent Court of International Justice at The Hague until 1942, just 1 year prior. And Matsushita Masatoshi was a political scientist and lawyer, and he was a defense counsel at the Tokyo IMT. I'm just not quite sure who he defended, actually. So you can see that that there's a certain that people already had quite some thoughts about about international criminal law and about the tribunal before it even started. And this very much conditioned views on Japanese on individual responsibility. Now, Actually, it was quite, the Tokyo trial was quite welcomed by the general people. They liked the idea that Japanese military leaders mostly were being punished for misleading the Japanese public. And by the by, also exculpated the Japanese population, therefore. And public intellectuals then downplayed the accountability of the Japanese population. Maruyama Masao called it the system of irresponsibility. And you can see this, this path dependence, the very political view of international law, the very Machiavellian view of international law, also in Takayanagi Kenzo's, he has been mentioned for a couple of times already, arguments against individual responsibility. Here you see he's not very fond of the idea. He calls it vicarious liability, illogical Anglo-Saxon doctrine, Hitlerite justice, that's an echo of Thomas Betty, I think, of vague popular feeling, the antithesis of justice according to law. And he uses various strategies to counter the doctrine, this illogical Anglo-Saxon doctrine. And yeah, well, that should have been on the screen. You can read it now. And he uses various strategies, and he uses both positivism and natural law doctrine. These are two examples of of his arguments, in which he uses mainstream positivism and also Hobbesian naturalism, arguing on the one hand that it's post facto retroactive law, and since we don't have a world government, this cannot individuals cannot be punished for crimes of the state. There should be collective responsibility. But then he also uses Hobbesian naturalism in that he argues statesmen will never be disposed to make aggressive war in the face of probable defeat. And if their country is not defeated, they are likely to be penalized. The risks of defeat are terrible enough in themselves to be a most potent deterrent. And in the anticipated event of victory, penal consequences are no deterrent at all, for the victor will impose them instead of suffering them. Indeed, such a doctrine of individual crimes of leaders may have the most deplorable effect of making future wars more cruel and inhuman. Since time is running out, I should conclude that as you can see here in the same defense, we have a rather formalistic argument on the basis of strict positivism and rule of law. On the other hand, an ultra-realist line of reasoning that could be almost taken from a textbook of Hobbesian naturalism. It would be wrong to misunderstand the relation of both arguments as one of pretext and real intention, or honne and tatemai, to use the Japanese cliché. Both positions, mainstream positivism and Hobbesian naturalism, functioned as two sides of the same coin that was Japan's historical engagement with international law. What connected both and transcended apparent contradictions of this ambivalent attitude was a highly politicized view of international law that saw law as a medium of Staatsräson. It is for this reason that many Japanese at the time embraced the principle of individual responsibility, albeit less for legal than for political reasons, as it meant trading the individual responsibility of 28 people against the collective responsibility of the whole nation and its figurehead, the emperor. In this interpretation, individual responsibility at the Tokyo IMT had a sort of sacrificial function. Thank you very much. And I'm sorry that I forgot to scroll down, so this is again the minutes which I had read to you of this committee which talked about the post-war order when Japan had won, and about Japan's generosity of not conducting an IMT for the United Nations.
Indeed. Thank you so much, Matthias, for it is all new to me that there indeed was a plan even before the IMTFE had events turned another way. and that, in fact, there is a long history of Japanese debates on international law. I feel a bit responsible for having brought up Judith Schlar's legalism yesterday, although I think it was Gary Simpson who actually quoted, where's Gary? Who actually quoted Judith Schlar. Well, just to explain, Matthias, I acknowledge that indeed there were discussions in Japan that explicitly addressed international law. What I meant was more in reference to current debates in Asia. The jargon is the Asian values debate. The Asian debate on whether the rule of law is just a thin veneer over deeper cultural impulses, that these things are dealt with not by courts, not by lawyers, but by quiet behind-the-scenes discussions. Just to summarize it rather briefly. And so the material that you give us, of course, support the point that you make. It's just that I was referring to, a parallel debate, I would say, in comparative constitutional law. Okay. As I announced, we will proceed straight to questions from the audience, and I will just reserve the last 10 minutes for the panel to have closing statements. I now open the floor to questions. Professor Crow.
First of all, Professor Cribb, I really appreciate your presentation because it shows that you've gone deep into the transcripts and have an understanding of the dynamics of so much that is going on. And in that context, I want to bring up, it's a two-sided question. Several of the Japanese defense attorneys made the point in their presentations or closing arguments that we are not Nazi Germany. And the second part is they're buried deep into the trial, and some of this evidence is the issue of Japanese cannibalism. And there is even one document in which a commanding officer actually gives his lower officers the opportunity to cannibalize POWs. Well, the point here is, and it comes back to the question of local level criminality vis-a-vis, say, international to national policy, is that one of the things that's brought out in the trial is that in many cases, the Japanese soldiers were almost in as dire straits as the prisoners. And the cannibalism flowed from the fact of malnourishment among the Japanese troops. And I think this is the reason that the Japanese attorneys made a very big point of we're not Nazi Germany. You know, they really felt offended by this allusion in parts of the trial, and I wonder if you would just expand a little bit on that.
Can I take two more questions before we proceed? Yes, Professor Totani.
Thank you. I have a question for Professor Cribb and another for Professor Askenova. My question for Professor Cribb is this. Could you explain why you say that the tribunal prohibited the defense from presenting the evidence that challenged the prosecution's case? Because that's contrary to what the transcripts of the court proceedings show. I read, I did read all the sections in the transcripts that pertain to war crimes by the prosecution and the defense, also including the defense evidence relating to individual accused. So I'm quite puzzled by this comment. But I can see why you would say that. Justice Webb does say at one point, and I think we are looking at the same page in the transcripts, Webb does say at one point when the defense presented some letters by former POWs or civilian internees saying, "Thank you, Commander X in such and such POW camp, for your good treatment, for your considerate actions to protect us, etc., etc." And Webb said that Of course there are some good Japanese who try to do their best to treat the POWs and the civilian internees. But to present these kinds of letters is just beside the point. Your task as a defense lawyers was to address the specific allegations made by the prosecution. So he pretty much says to the defense that to do that. And so the defense was given the opportunity to do so on two different phases. Sorry, this comment is getting a little bit long, but I will try to be as concise as possible. The defense had an opportunity to address the prosecution's evidence broadly, and then to address the prosecution's evidence with regard to individual accused. When the defense had the opportunity to address the prosecution's evidence generally, they did actually quite little. So much so that what they did was tantamount to admitting much of the allegations. And when it comes to individual phase, the phase for the individual accused, the defense did try to counter some of the evidential materials concerning specific instances of atrocity. They did so by two ways. One is to just flatly deny that these things happened. And second was that they didn't know anything about these atrocities if they ever happened, so I could not be held accountable. Or thirdly, they admit that some of these crimes were committed or may have been committed, but that they did not have a superior authority to address these problems. So I think I just needed to make this comment because it's so misrepresents how the defense dealt with the prosecution's case. Just take, for example, the rape of Nanking. When the defense was given the full opportunity to address the prosecution's massive evidence documenting, massive rape, burning, looting, destruction of the property, killing, etc. What the defense did was to present just 3 or 4 pieces of evidence, and which is nothing. When it was the phase for the defense to present evidence on behalf of General Matsui, what the defense did was to basically admit that some of these atrocities were in fact committed, and that Matsui knew about it. The main defense line was to say that Matsui, although he had been uninformed, he was not able to do much about it because he did not have that kind of power or authority to take control of the situation. That was the main defense line. With respect to prosecution's evidence on massive rape beyond Nanjing, the defense response to that was, yes, in fact, rape was commonplace. It occurred at other places, beyond Nanjing. It was so concerning, according to the chief legal officer of the Japanese Army Ministry, I think. Or it might have been Army General Staff. He says that we were so concerned that we had to introduce a revised law that would make it easier to court-martial suspected offenders of rape.
Yes, Professor Totani, and you're addressing the point to which of the speakers?
So this, So this was a long and winded way of posing a question to Professor Cribb.
Okay.
Why do you say that the prosecution, the defense was prohibited from presenting evidence that challenged the prosecution's case, which I think is patently untrue? I have another question for Professor Aksenova. Could you please comment on some of the individual cases, individual verdicts? You've said a few things about sentencing, and especially with regard to Shigemitsu. Perhaps you can expand on it a little bit and say, as you read the judgment, were the major legal and factual findings by the tribunal about this case or any other individual cases that interested you?
Thank you, Professor Totani. I'm sorry. And I think I saw the hand of Professor von Lingen. Please.
Thank you very much to all the three speakers for very inspiring and really interesting lectures. I think as Yuma has just dealt with the question I wanted to pose to Robert Cribb, I go directly to Matthias Sachmann. I'm very interested in this document you have been presenting because the issue of reparation comes up, for example, with the French team as well. So they are quite surprised to be called into a tribunal at Tokyo because they would have preferred way more to just pose a bill to the Japanese government and say, so, well, this is our claim, we would like some reparations to be paid. So this is interesting to see that the Japanese document claims that this is a Western way of forming trials. On the other hand, I'm always having this idea of global justice between Europe and Asia. And I'm wondering, because I know that the Nazis at some point had this idea of staging a trial on the American or British war criminals or the Soviets, for example, and it's this Wehrmacht-Untersuchungsstelle, this inquiry commission, which collects evidence on atrocities committed by the enemies. So I'm wondering whether Japan has a similar body to let's say, prepare if there is the need in the future to hold a trial. Thank you.
So, thank you so much, Professor von Lingen. And who would like to start with the replies? Robert.
Thank you. Thanks very much. First to Professor Crow, is the theme presented by the defence, the Japanese defence, that Japan was not the same as Nazi Germany was indeed very strong. And when we look at a great many of the atrocities, we do find that they're local. As it happens, the first Australian trial of a local Japanese for war crime was a cannibalism case. The defendant was found guilty and sentenced to death, but then on review, the sentence was reduced to 5 years on the grounds that he was indeed starving and that he didn't have any choice. We have a number of really horrible cases of descent into cannibalism, beginning with the eating of bodies of Japanese soldiers who died in conflict, then the eating of the bodies of enemy soldiers who died, and then ending up with the hunting of humans for meat. It was a really horrible sequence of events. But these things were all happening locally rather than as a result of any command from Tokyo. Professor Totani's point, yes, that's really important. So I wasn't making quite as broad a claim as you attributed to me. Webb made it very clear that the defence was not permitted to bring as evidence testimonies that indicated good, or that reported good Japanese behaviour. This was, in some respects, standard legal procedure. You have to answer the charges that are brought against you rather than bringing in other favourable cases. But because of the nature of the prosecution charge, that the atrocities were of such a scale and of such a consistency as to constitute policy, it actually was relevant to consider that some camps had been a lot better than others, some commanders had been a lot better than others, that the overall pattern of wartime atrocities had been very uneven across time and space. It is absolutely clear, and it's shown through the national level trials, that there was a vast number of atrocities committed across the Asia-Pacific region. What I was pointing out particularly was that the nature of the evidence that was admitted in Tokyo meant that for the international public record, and there was a direct connection between the evidence presented in Tokyo and Lord Russell's Knights of Bushido, which then contributed to the broad image of comprehensive Japanese atrocity, that image arising from the evidence presented to the court created an overall misleading impression of the nature of Japanese wartime atrocity.
Thank you very much, Robert. I also wondering when I was listening to the account of Professor Totani about the defense strategy. Maybe their strategy was like sort of confession and avoidance, like, yeah, sure, I did it, but I had a good excuse. But anyway, I'm just speculating here. Marina.
Thank you for the question about sentencing and specific cases. As I mentioned, there were no general rules regarding sentencing. So the verdicts, yes. Yes, the verdicts of the particular accused. So the verdicts, the one I would like to perhaps discuss in a bit more detail is the one given to General Dohihara, which was a death sentence. It was given to him because he was intimately involved in the initiation of the war of aggression waged against China. He spent 18 years in China. So what was particular was that the tribunal emphasized his special knowledge of China and particular involvement with China and his extensive role over a long period of time in Japanese structure. He was sentenced to death because also he was convicted of a war crimes charge, count 54. So the level of his engagement was very, very extensive and very diverse. And the other important element that the tribunal emphasized was his collaboration with other members of the conspiracy. What is also particular is that the tribunal did not name them. So that was the general strategy of the tribunal, which would probably not be accepted in modern international criminal law, to stress culpability, to say that the involvement was very extensive, indeed over 18 years in different roles, but not to name other people involved in the same commission of crimes. So this would be the case that attracted my attention. But as I said, it was case by case for each accused. There were no legal rules as such. It was more factual. Thank you.
Thank you, Marina. And Matthias.
Thank you for the question. Well, I think one reason why, Japan's war history was always like that they demanded high reparations, but then that's it. They had very good success with the first Sino-Japanese war doing this, and probably that's also a bit of path dependence. About agencies collecting data on crimes against Japanese or allied war crimes. There is a mentioning that diplomats stationed in foreign countries were collecting data. But then they say this is just for documentation. This is not, we will not make use of this after the war. And then there are, of course, as I mentioned, there are war crimes trials in Japan and in occupied territories, in Japanese occupied territories, of enemy soldiers. This Gunditsu Hote, the Japanese military courts, and they tried enemy soldiers if they had committed grave war crimes. Grave war crimes often meant aerial bombing. Finally, I should add, since you mentioned Germany, this document is also extremely interesting about Japan's relations with Germany as a Dome pact country. For example, they discuss about the mass atrocities, mass killings of the Jewish population in Germany, and discuss should they do something about that. And then they say, no, Germany is an allied country. This is an internal affair. Better hands off. But it's a very detailed document about visions of post-war order. Men in the high castle moment, so to speak.
We will now take a second round of questions, and we are trying to fit a third round if possible. I see the hand over here. 1, 2, and 3. Okay, we have the next round, please.
My comment was to
the microphone is over there.
Sorry. My comment was to Professor Zachman. I read Judith class Legalism twice in the last few months. My impression is that she's being very ironic. And one needs to read a lot between the lines. In the sense, first of all, I don't think she would say that the Japanese don't know anything about natural law. But her bigger point, that the idea of a monotheistic Christian idea of divine command being natural law would not really have traction among the Japanese, I think we would probably agree with that. So even if the Japanese know about natural law, they would not be convinced by Kenan's monotheistic logic. But the more important point is actually the Holocaust. Because she is criticizing the argument which Kenan makes that there is a millennial Judeo-Christian value of good versus evil which is being used to punish the Japanese. And she immediately says, well, there is no Judeo-Christian millennial heritage. If anything, there is a centuries-old heritage of European anti-Semitism. And she makes the point that, of course, there is a distinction between the Holocaust and the Japanese crimes. So she is actually trying to puncture Kenan's hypocrisy by pointing out that the anti-Semitism which lies and the racism which lies at the heart of European culture, rather than European culture being about rule of law and Judeo-Christian, this binary. She's being very, very ironic about that binary. And I think probably her remarks about the Japanese is not really a factual objective statement, but more a critique of European kind of self-projection of itself and so on.
Thank you. And I saw the next hand is, I think, Philip.
Me? Yeah, thank you. Philip Amba from the ICC. I had a quick question that goes back to the mode of liability, command responsibility, that goes to Professor Aksenova. You said that the standard used at the IMTFE was one of reckless disregard, which I agree with you would be akin to our Article 28 for the civilian commanders. And my question goes a little bit to the question of how much value in terms of jurisprudence guiding us forward does this have? Because I note that the Geneva Convention's Additional Protocol 1 applied a different, more open definition, which is should have known, something that then ICTY, ICTR, and the ICC in Article 28 picked up again for the military commander. Now my question again is really, does this have jurisprudential value, the IMTFE, because it's something that you would not necessarily read. You read Yamashita, but not necessarily this. So my question here, was it too restrictive, or was it what you could do at the time, and then we just moved on from there in the 70s? Thank you.
Thank you so much, Philip. And the third hand is over there at the end.
Thank you very much for very interesting and informative presentations. My name is Yayoi Yamaguchi. I'm from the ICC Office of the Prosecutor. I have a question related to one point raised by Professor Cribb relating to the scarcity of documentary evidence linking senior leaders to the crimes on the ground, which is one of the challenges we often face in the cases before our court. And I was wondering if you can tell us about who was responsible for collecting evidence, which must have been scattered in various different territories occupied by the Japanese military, and to what extent the defense also had the possibility to collect evidence in favor of the accused. Thank you.
Thank you. The last question came from a representative from the Office of the Prosecutor of the ICC, and the second to the last was from Philip Amba, who heads the Victims Unit of the ICC. Maybe we should start the answering from Marina.
Thank you for this question, Philip. With regards to the jurisprudential value of the standard of recklessly disregarding the duty to secure the observance of the laws of war, that was the standard. What is interesting, I find, in the Tokyo judgment is the way it was applied. Again, I have to stress the factual aspect of the judgment. So I would say that the Tokyo Tribunal went even further than the should have known standard. So the mens rea is even lower than the should have known, because the way the standard was applied was that it was not enough for the exculpation of a person that they accepted assurances that the crimes were not committed. The Tokyo Tribunal required people to resign from the cabinet, also people to take extra steps even when they were assured that crimes are not committed. So it was not even should have known, but it was a step further to should have known, extra duty of care. So yes, the standard is reckless disregard, but then factually, the way it was applied, it's even a step further. So I can imagine a situation, a factual situation in the future in the ICC when something like that occurs, for instance, assurances of no commission of crimes, and then someone willfully or blindly disregards or accepts these assurances. I guess in criminal law, in some domestic jurisdiction, it's called willful blindness. So that could be that could have some possible precedential value, and that's why I think the factual element of the Tokyo judgment is actually valuable in some ways, because it allows a scope for further development of law in different directions. Thank you.
Matthias?
Well, it was more of a comment, so with which I perfectly agree. It's just that Sklar is not always the most clear writer. She's often too ironic for her own good. And the fact is that there are different natural law views. And in that sense, Sklar actually seems very much to agree with the Japanese defense, who also tries to deflate Keenan for his very pompous and sanctimonious pretensions to civilization and this Judeo-Christian views of natural law, and uses a different kind of very ultra-realist view of natural law. So it's actually one natural law against another doctrine, natural law doctrine.
Thank you, Matthias. And Robert.
Thanks very much. The process of collecting evidence was vast and complicated. It began during the war in the hands of various national governments, many of which coordinated or paid some respect to the United Nations War Crimes Commission and dispatched summaries of evidence to the UNWCC. Australia held 3 commissions investigating Japanese war crimes. The United States set up special investigation bodies. In the case of Britain, the investigations didn't start until after the war, but there was a large number of war crimes investigations teams which fanned out across Southeast Asia to gather material. On the British and Australian side, the most extensive collection of information came through prisoners of war. There was a general survey. Every prisoner of war had to fill out or was asked to fill out a so-called Q form, in which he or she would identify very generally whether they had any information about war crimes. Those Q forms were then followed up to generate affidavits. The most comprehensive investigation overall was certainly in the Philippines, where there was a very clear process of gathering rumours, gathering gossip, gathering any possible information to try and identify war crimes, both against prisoners of war and against local people. These were then followed up by investigation teams. They were transformed into detailed reports, which were then measured against the record of Japanese held in captivity. and against the record of Japanese soldiers who'd been sent back to Japan. So there's a major process of rearresting, or rather arresting, repatriated Japanese soldiers who were identified as war crimes suspects and then shipping them back to Southeast Asia. So it was a vast effort, and it means that the Japanese wartime atrocities are by far the best documented atrocities in Asia in the 20th century.
Thank you so much, Robert. A Filipino historian noted that the witnesses remembered best the Japanese accused who spoke English, because then they sort of had a connection at the moment, which might have ended up to be more unfair, because possibly those who spoke English were the better educated and might have been kinder to them. But again, that is a matter of speculation. We now have the last 10 minutes, and I promised my colleagues that I will give them a chance to give their closing statements. And who would like to start? Robert, would you like to start, please?
I'll just add something in further response to Professor Tuatani. One of the trials, the national level trials, fall into two categories. There are trials which investigate specific events, specific brutalities, specific murders, and there are trials that are based on a general pattern of brutality. So many of the prison camp trials relate to a general pattern of brutality. They don't rest on any single incident, but they rest on many stories of brutality by guards, whereas others rest on specific cases. Now, the Nanjing massacre, which was brought up in the Tokyo trial, was similar to those national level trials which focused on a specific incident. Those trials resembled far more closely what we'd think of as a normal criminal trial, looking at events, looking at sequences, looking at individual responsibility for specific events. The trials that were based on general patterns of atrocity were more difficult, because the evidence was often much more fragmentary, and each individual piece of evidence was less reliable. In the case of the Tokyo trial, we have a general pattern of atrocity being presented, very often with evidence that was collected for the national trials, and generally with pretty reliable evidence. But there is a distinction between the trials that focused on individual events and the trials that focused on general patterns.
Thank you. Marina?
Thank you. My main conclusions would be that I see both the legacy of Nuremberg and Tokyo as living instruments. There is certain propensity of the legal mind, as Judith Sklar pointed, to think of law as there or not there. But she also pointed out in her work that law can be a matter of degrees or subject to development, as I interpret it. So we tend to think of law also as being progressively developed, and I don't always agree with that. I think law develops in cycles or in certain stages, and I think that Tokyo judgment may be of relevance in the future as a legacy instrument in this further development. And when I was doing research for my book on complicity in international criminal law, I looked at preparation of the Nuremberg Charter and then later Tokyo Charter. And what struck me is that it was not a given that we had these trials, the Nuremberg and then the Tokyo. So the discussion was there, what to do about the perpetrators of mass atrocities. And I think it's a huge achievement that despite all the flaws, despite all the difficulties, the discussion still takes place within the legal domain, within the framework of a criminal trial. So this is a big achievement, and perhaps that's a source of my optimism in this regard. Thank you.
Thank you. And Matthias?
Thank you. Well, I just can reiterate my credo that We have to see the trial in a historical context. I know that jurists often do not like that because it dilutes their doctrine, but nonetheless we have to see the Tokyo trial as a point in a historical trajectory, and the historical development towards it shapes the perspectives of the Japanese response of the trial, and of course also what comes of it, how the attitude afterwards develops in Japan. As we have said, maybe legally it may not be so influential, but politically it became and is still very influential in the Japanese discourse. And we can understand why, in the beginning, the Japanese majority welcomed or did not reject the trial, but eventually there was a flip when Japanese attitudes became more critical towards it, which has little to do with the legal perspective and much more with the political view of international law in Japan, which has a long tradition. Thank you very much.
Speaking as a judge, I am fascinated by what the speakers have taught me this morning about how much the law can learn from history, and how much the historical context can shape even at the technical level of the presentation of evidence of in a case, and the way the evidence is appreciated. And in fact, with Matthias's line earlier that it was a contest of Kenan's natural law versus the accused's natural law will bring us to yet another field, which is legal philosophy, and and also yet another layer is the interface between the international level prosecutions and the domestic level prosecutions, which will have a different focus and a different flavor altogether. And for that, we must thank the organizers, the International Nuremberg Principles Academy, for having brought together the speakers today. Thank you.